Tim McIndoe.
Move that the question be now put.
I'll call Louise Wall. Sorry.
Thank you, Mr. Chair. Actually, I'm going to dedicate my whole contribution to the supplementary order paper of my colleague Jan Logie, and it is the one that wants to insert intimidating after misleading. And the reason I want to do so is because I've just been reading from MacDonald and Tinsley and why they say it's so important. So just for the House's information, Section 85 is about unacceptable questions that are put to witnesses, to victims a lot of the time, and some of the criteria that we use to determine whether those questions are acceptable or not from the section are that you can't ask questions that are misleading. So that's giving the wrong idea or impression. You can't ask questions that are improper, which are not in accordance with acceptable standards. You can't ask questions which are unfair, so they're not based on or behaving according to the principles of equality and justice. You can't ask questions that are needlessly repetitive or expressed in language that is too complicated for the witness to understand. And so when I look at what intimidating means, definitions are really important, and it means to frighten or overawe, especially in order to make them do what one wants. It also means to frighten, to terrify, and to scare. And I couldn't imagine us wanting to frighten, to terrify, or to scare any witness that was providing evidence in the court. So I just actually don't understand what the issue is. So what MacDonald and Tinsley said was that if we add intimidating, and overbearing was the other word that they used actually, it was noted the cause for greater judicial management of inappropriate cross-examination and considered such a change may assist such judicial control. And it also noted that Section 85 is about giving the judge a wide discretion to control the nature of the questions and the manner in which they are asked. So I think that some may see as a little amendment, but I actually think it's quite a big amendment because it speaks to the integrity of putting victims at the centre of pieces of legislation. And so I stand to support this supplementary order paper, as does the Labour Party, and I want to commend Jan Logie actually for her passion and for bringing to the House supplementary order papers that are going to enhance this particular piece of legislation. I think that she speaks for members of communities that she is actively involved with. She does a lot of work, as others of us do, but Jan particularly with Women's Refuge, with women's organisations, with victim support, with organisations that entrust her to come into this House and to speak for them. So I would implore this House and the Minister and other members of Parliament to add intimidating to Section 85, which ensures that witnesses who are being cross-examined aren't frightened, aren't overawed, aren't terrified by the experience. We've talked a lot about, the minute number of women actually who stand up and have the strength to go through the judicial process. Not enough women stand up and make complaints. And so we want to empower those women who do with a process that isn't going to frighten, terrify and scare them. And so I think that this is one of the SOPs that, as I said before, strikes to the heart of what this bill is trying to achieve. And so, again, I hope that there will be some common sense tonight and that we as a Parliament will at least pass this supplementary order paper. Kia ora.
Maureen Pugh.